We will be discussing the question, LLPs. What are they and why there's so few of them in the UK? This question is asking us to explore the area of partnerships and what it means to be an LLP. We find this field interesting as it's fairly new law and a new form of company, and so exists within our generation as a new type of business operation, produced with the use of new yet beneficial legislation. In order to discuss this question, I will be introducing limited liability partnerships and outline their legislative definition. I will explore its similarities and differences with limited partnerships and limited liability companies. Second will be Esther, who will explore the duties and responsibilities of the personnel within LLPs, in particular its members. Finally will be Arslan, who will identify both the positive and negative aspects surrounding LLPs in order to investigate why there may be so few of them in the UK. So an LLP is the abbreviation of the Limited Liability Partnership and exists when a corporate body takes on a legal entity separate to that of its members, so that its members may have limited liabilities. The business is owned by two or more people and shares similarities with both the limited partnership and the limited liability company, abbreviated to the LLC. The Partnership Act 1880 highlights the relation which subsists between persons carrying on a business in common with a view of profit. This serves as the primary similarity between LLPs and limited partnerships. The LLPs is a type of partnership. The difference comes when the limited partner has joint and several liability and therefore has unlimited liability against the losses and debts that the company ensues. He is personally liable for those losses that inevitably result in the loss of personal assets, such as his home. Dissimilarly, the partners of an LLP have a limited liability and essentially a limit to the loss of their assets. Whilst the limited partner takes personal responsibility for the liabilities of the business, the limited liability partner has protection against his responsibility and personal assets, resulting in losses that generally amount to the sum of his primary investment. Again, the LLP is similar to the LLC, where liability is also limited, similar to that of the shareholders of a corporation. The legal entity of the company is also separate from partners, who are also the owners of the business. However, limited liability partners have the right to manage the company themselves, allowing the right to make day-to-day decisions in the running of the business. This differs to the shareholders of LLCs, where a board of directors must be elected, who in turn manage the operations of the corporation. LLC partners therefore have no place in the management of the corporation.
I will briefly just discuss the laws around the company name. It's very important to note that the company is required to display LLP next to their company name and on any advertisements, stationery, etc. Regulations made under the Companies Act of 2006 require the LLP to display its name at its registered office, other places of business, on business documents and websites. The purpose of the regulations is so that the legal identity of every LLP is revealed to anyone who have or may wish to have dealings with it. In addition, the company must include the names of all its members unless it's over 20. I will now just discuss the personnel required within the LLP and what their duties are. A member of the LLP is much the same as a shareholder within a limited company. They also, however, are the owner of the company. In an LLP, there are various rules regarding the members and who is actually required for the company. As the format of the company is somewhat between a company and a partnership, there thus needs to be clarification on the exact roles required. In a partnership, the only legal requirements regarding personnel is that there are between 2 and 20 joint owners, all of whom have unlimited liability for financial losses. In a corporation, there must be a minimum of 1 or 2 directors within a public limited company requiring a secretary as well. Therefore, an LLP sits somewhere in between the two. An LLP must have at least 2 members present, and if the number falls below 2, there are usually grounds for winding the company up from the form of LLP. In addition, there is no upper limit on the number of LLP members. Upon original incorporation, the members of the company are those who sign their name on the incorporation document. By doing this, they receive a limited liability status whereby they are only liable for the amount of money they put in, while still receiving the benefits, for example taxation, that a partnership may receive. Each member is automatically deemed to be an agent of the LLP. This is much the same as in a company, meaning they must act in a way that shows duty of care to the LLP and its activities. Duty of care includes carrying out the instructions of the LLP, exercising appropriate care and skill, behaving honestly and not accepting inducements or personal profits in respect of the business, and not allowing conflict of interest. The members are able to be either a corporation, i.e. a company, or actual humans, provided there are at least 2 present. They must sign an incorporation document which sets out the first designated members and any additional members that are added since then. In addition to the duties of an ordinary member, a designated member has the following additional responsibilities. They must appoint an auditor, sign the LLP's accounts, deliver the accounts to the Registrar of Companies, and notify the Registrar of Companies of any changes in the LLP's register office, membership or name. Also, they must complete and fill out the annual return form and act on behalf of the LLP if it is wound up. The next two acts are found from the LLP Act of 2000, and I found the legislation which outlines the actual requirements of each member regarding how they must act within accordance to each other's actions. The following has been directly selected from the Act. Every member of a limited liability partnership is the agent of its members as a limited liability partnership. Agents are not bound by anything done by a member in dealing with a person if A. the member in fact has no authority to act for the limited liability partnership by doing that thing, or B. the person knows that he has no authority or does not know or believe him to be a member of the partnership. This basically means that each member is not responsible for the other's actions if they have no legal requirements to do so, or if they know that the action has no impact on their own liability. As well, from the LLP Act of 2000, the following piece of legislation regards to the winding up of the business and the liability the members hold. The amount of liability of a member of a limited liability partnership on winding up is the amount at which A. he is liable to contribute to the assets of the limited liability partnership, or B. he remains liable also to contribute for the period of at least 5 years beginning with the relevant time, or until it is wound up if that happens before the end of that period. And this basically means that the amount of money that the member put in is the only financial loss he will incur, and that they will not have to provide extra finances to pay off any debts due to the idea that they are a separate legal entity to the company itself. In addition, the final clause, B, indicates that the member must contribute for at least 5 years from the beginning of the company. As well as the members, the company also obviously has the right to employ others, and so the members have also got the added responsibility of ensuring all employees receive the correct pay and are registered with HMRC for taxation and national insurance reasons. So as can be seen, the members have many responsibilities, and these responsibilities are taken on by that of the shareholders of the company with the added pressure of actually being the direct owner, portraying that there's a great deal of responsibility for those wishing to engage in such a construct, which may hint to why there's such limited success. Next, Arslan will discuss the second focus of this question, delving into the reasons behind why there may be so few in existence.
I'm here to talk about the reasons why there are fewer LLPs in the UK. From the table, statistics from the company's house, we can clearly see that the numbers of LLPs are very less in comparison with the numbers of non-partnerships and companies limited by shares. Limited liability partnership has been practically available since 6 April 2001 as a new type of business structure with outweighed advantages such as offering limited liability for people who are already in business and who are about to set up in business, and it protects their personal property, profit, etc. I will try to look the reasons behind this reluctance. One of the reasons can be unfamiliarity. In his discussion with accountants, consultant Michael reveals that accountants who have yet to take on any LLP clients are unfamiliar with the required layout of LLP accounts. And a cynic might suggest that accountants don't typically recommend LLP structures to the clients because it has recurring accountancy fees, are higher for company account and the related company secretarial and tax work as well. Then another reason can be that it is a newer form of business structure and it is only made legal by Partnership Act 2000. And it's very young compared with the more familiar private company limited by shares. So when something is new, it requires time to be accepted by public. This can be another reason in the less number of LLPs. And according to Derek Phillips, initial skepticism is another reason for the less number of LLPs in the UK. No wonder people scratch their heads and ask why form an LLP. For the first few years, there was indeed just a trickle orders for LLPs. Initial skepticism can be the reason for this, but now there are increasing awareness that this is a useful way for many businesses to protect their assets through limited liability. In addition, most of today's business owners and managers were educated at a time when the partnership and limited liability were mutually exclusive. Maybe these ideas still exist in today's business owners' mind. So, according to Simpson Group in their publication, they say that if a trade or profession is being carried on in a normal partnership and is then transferred to LLP, there should be few problems as long as the business and assets are transferred. The transfer will not give rise to a disposal for capital gains tax purposes, provided that certain conditions are met. And it should be noticed that, however, that the cost of conversion to LLP may not fully qualify for tax relief as well. And also LLP do not pay corporation tax, but some people who think about converting their business to LLP do not fully agree that they would pay less tax on a company profit, because all the profits of the company are regarded as the members' income and are subject to income tax instead. So the balance of tax advantage depends on how much profit the company might make and how much the owners pay themselves. In addition, even Alan Watts and Helen Evan claims on their article on Legal Week that being an LLP member could become more taxing because of the last proposal from 6 April 2004, that this proposal will use economic criteria to determine whether LLP members are to be taxed as employees or self-employed. So this threatens to limit the appeal of LLPs. And another problem is transparency problem. According to Mike Reeves, the transparency of accounts may not be attractive for some business owners because they don't want to give their business secrecy to the competitor or to give information about their losses in market. So, but when you are choose LLP as the business structure of your firm, so your information will be publicly available. So another problem can be lack of registering limited partnership agreement at a company's house. The LLP Act does not require a limited partnership agreement to be registered at company's house. This has the advantage that its terms are not made public. On the other hand, there is a danger that this will tempt people to register as LLP without having a suitable LLP agreement. And as there is no equivalent document like in companies buy shares model articles, the firm and its members will have only limited terms from the LLP regulation to govern the relationship between them and the LLP itself. So this will rarely be adequate and in some cases will entirely be unsuitable and can cause the problems among members. So another reason for the less number of LLPs in the UK can be that it's only available for the organizations who make profit. So a statement of company's house forms for LLP registration confirms that the registrants are joining in business for the purpose of making profit. That excludes non-profit enterprises such as clubs or charities or any dormant organizations. And it also excludes non-trading companies. And this part affects the number of companies registered as LLP members. So another problem can be selling of LLP. A private company limited by shares is more anonymous and easier to separate from the owners by means of transferring the shares. A partnership is more personal and therefore less straightforward to separate from the owners, and this led to difficulties when members consider selling the company. In addition, making some certain changes, for instance alteration of capital structure or transfer of shareholder, is much easier with limited company compared to LLP. Maybe this is the reason distract the owners of the business, which was LLP. Another problems can be investing problem. So an LLP could be less attractive than a limited company when considering external investment, and some certain creditors nowadays may require personal guarantees, thus diluting the advantage of the limited status. And another problem that if a person who chooses LLP as a business structure then want to transfer it to companies limited by shares, I mean LTD, so they cannot do it. My friends will go on about the challenges and conclusion.
Academic sources provide a conclusion for our question and shed light on the reasons why there may be so few LLPs in the UK. Friedman claims that the LLP form is an unsuitable vehicle for most small owner-managed, non-professional LLPs, and its importance should not be exaggerated. First, Friedman argues that because the LLP has a lack of rules on internal governance, this means that it offers no standard form of constitution and would, therefore, be expensive to set up for small companies. Second, in its adoption of company law, this has resulted in greater complexity and a set of provisions which are very difficult to use. Third, Friedman states that the LLP has extensive disclosure and filing requirements relating to the link between limited liability and disclosure in the UK doctrine. Even though small LLPs are exempt from the full disclosure of accounts, Friedman argues that a lack of formalities should not be presented as an advantage for LLPs. Fourth, the LLP requires at least 2 designated members, whether individual or corporate, something that is not always relevant to a micro-owner managed business. For this reason, Friedman argues that for the one-person LLP, it is simpler to incorporate. Fifth, the LLP format offers tax reduction, but she points out that commercial decision-making may be distorted in that the LLP provides tax savings because of capital gains tax differences and a lower rate of NICs for the members who would pay more as employees in an incorporated situation. For small LLPs, Friedman argues that the LLP may be disadvantageous from a tax point of view, compared to a sole trader or general partners, as losses available for relief against general income cannot exceed the capital contributed by the member. Lastly, Friedman is critical of the limited liability protection and argues that there is still a great deal of ambiguity as to whether the LLP or the individual member would be responsible. In such situations, the court would need to consider various factors, including the assumption of personal responsibility of the member, reliance on that assumption by the client, and whether that reliance was reasonable. The Act leaves this area purposefully ambiguous, suggesting that this will be resolved via the judicial process. Gary and Wayner report on the cessation of membership by a partner in an LLP. In the absence of a partnership agreement, neither the Act nor the regulations set out the financial consequences of the cessation of membership. This resulted in litigation and dispute whether between the remaining partners and existing partner. Therefore, it is the existence of these several challenges to a small-scale LLP that result in a lack of members in the UK. Referring to data gathered from 2011, there are over 40,482 listed LLPs, over half of which were small-sized firms. Explaining how so many UK LLPs have faced so many problems and why so few of them may exist.
Okay, finally I'm just going to discuss overall challenges that face LLP businesses based on a report by Grant Thornton, which is named LLPs. Firstly, there's pitfalls relating to tax that, as Arslan discussed. Secondly, they must consider the VAT position as costs can arise from this. After that, there's employment rights of the employees must be considered as they become members. Also, the pension arrangements may change when becoming an LLP, and there are also various regulatory requirements for the protection of creditors, and they must file their annual accounts, which can be lengthy as opposed to partnerships which don't have to. Finally, they're unable to take advantage of share schemes which allow employees to own a share, as the shareholders are also the owners of the business. And so to conclude that, not all LLPs are appropriate in all circumstances. And that's the end of our presentation. Thank you.